I note the presence of His Excellency Philemon Young, President of the 79th session of the United Nations General Assembly in the Great Hall of Justice today, in addition to the representatives of the many states and international organizations that have taken part in these proceedings. The questions on which the advisory opinion of the Court has been requested are set forth in Resolution 77/276, adopted by the United Nations General Assembly on 29 March 2023, by a letter dated 12 April 2023, the Secretary General of the United Nations officially communicated to the Court the decision taken by the General Assembly to request the Court to render an advisory opinion. The final paragraph of the resolution reads as follows, I quote, "The General Assembly decides, in accordance with Article 96 of the Charter of the United Nations, to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on the following question. Having particular regard to the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, the United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. A. What are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B. What are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to, 1, states, including in particular small island developing states, which due to their geographical circumstances and the level of development are injured or specifically affected by or particularly vulnerable to the adverse effects of climate change. 2, peoples and individuals of the present and future generations affected by the adverse effects of climate change." End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 37. The full text of the opinion will of course be available at the close of the sitting. When seized of a request for an advisory opinion, the Court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the Court should, in the exercise of its discretion, decline to answer the request. The first question put to the Court concerns the obligation of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases, which I shall refer to as GHGs. for states and for present and future generations. The second question concerns the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment, with respect to states and peoples and individuals of the present and future generations affected by the adverse effects of the climate change. The Court considers that these questions are legal questions. The Court concludes that it has jurisdiction to render the requested opinion. It then concludes that there is no compelling reason for it to decline to give the opinion requested by the General Assembly. Turning to the relevant scientific background, the Court notes that the consequences of climate change are severe and far-reaching. They affect both natural ecosystems and human populations. These consequences underscore the urgent and existential threat posed by climate change. In its examination of the scientific aspect, the Court relies primarily on the reports of the Intergovernmental Panel on Climate Change, which I shall refer to as the IPCC. Participants agree that these reports constitute the best available science on the causes, nature, and consequences of climate change. The Court further observes that the adverse effects of climate change on the climate system have been acknowledged by the United Nations, including UNEP, and its specialized agencies such as the WMO, WHO, and the IMO. The IPCC defined the climate system as the global system consisting of 5 major components: the atmosphere, the hydrosphere, the cryosphere, the lithosphere, and the biosphere, and the interactions between them. For the purposes of this advisory opinion, the Court notes that this definition is substantially equivalent to that of Article 1, Paragraph 3 of the United Nations Framework Convention on Climate Change, which I shall refer to as the Framework Convention. Article 1, Paragraph 3 of the Convention defines the climate system as the totality of the atmosphere, hydrosphere, biosphere, and geosphere, and their interactions. The IPCC has concluded with very high confidence that risks, projected adverse impacts, and related loss and damage from climate change will escalate with every increment of global warming. It added that these risks, projected adverse impacts, and related to legal consequences arising under those legal obligations in its reply to question B. Concerning the scope of question A, the Court notes that the unqualified In its view, in relation to question B, the Court is only called upon first to establish the applicable legal framework of by the adverse effects of climate change. The Court considers that whether individuals have any entitlement to invoke the legal responsibility of the state in its request, General Assembly invites the Court to have particular regard to, I quote, the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment." End of quote. The phrase, "particular regard to," while indicating that the wide range of international legal rules and principles are potentially relevant, does not mean that the General Assembly requests the Court to address every rule of international law, including the obligations contained therein in respect of climate change. The Court therefore identifies the most directly relevant applicable law governing the questions of which it has been seized. It first identifies those rules which are most directly relevant and thereafter determines whether any of those rules are excluded by virtue of the interpretative principle of lex specialis. The Court begins with the Charter of the United Nations, which is a pillar of contemporary international law. The Charter provides that the member states shall act in accordance with certain principles, such as the fulfillment in good faith of the obligations assumed by states under the Charter, including when addressing problems of common concern, such as climate change. Accordingly, Charter forms part of the most directly relevant applicable law. The Court then turns to the applicability of the climate change treaties. It observes that the Framework Convention, the Kyoto Protocol, and the Paris Agreement are the principal legal instruments regulating the international response to the global problem of climate change. These instruments complement each other. Framework Convention establishes the ultimate objective as well as the basic principles and general obligation of states in respect of climate change, whereas the Kyoto Protocol and Paris Agreement respectively translate these basic principles and general obligations into a set of more specific interrelated obligations, each of which gives expression to a broad, practical approach of the community of states parties to the problem of climate change. The Court thus concludes that the three climate change treaties, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement, form part of the most directly relevant applicable law. In view of the Court, UNCLOS also forms part of the most directly relevant applicable law. With respect to other environmental treaties, the Court considers that the following treaties form part of the most directly relevant applicable law, given their close connection with the issue of climate change. The Vienna Convention for the Protection of the Ozone Layer, which I shall refer to as the Ozone Layer Convention, the Montreal Protocol on Substances that Deplete the Ozone Layer, which I shall refer to as the Montreal Protocol, the Convention on Biological Diversity, which I shall refer to as the Biodiversity Convention, and the United Nations Convention to combat desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, which I shall refer to as the Desertification Convention. The Court is aware that there are many other treaties which are relevant for the efforts of the international community of states to address the global problem of climate change. However, it confines itself to examining the most directly relevant applicable law regarding climate change. The Court then goes on to consider the applicability of the relevance of customary international law. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court affirmed that the duty to prevent significant harm to the environment is not confined to instances of direct cross-border harm, and that it applies to global environmental concerns. In the Court's view, the customary duty to prevent significant harm to the environment also applies with respect to the climate system and other parts of the environment. The duty to prevent significant harm to the environment is an obligation to act with due diligence. The conduct required by due diligence has several elements to which I shall return later. Determination of what is required by due diligence ultimately calls for an assessment in concreto of what is reasonable and under the specific circumstances in which a state finds itself. However, this does not exclude the identification of a required standard of conduct at the general level, depending on the overall character of the risk to the parts of the environment in question. This is particularly apposite with respect to climate change, because the specific character of the risk of significant harm to the climate system is indisputably established. Climate change poses a quintessentially universal risk to all states. This risk is of a general and urgent character, requiring the identification of a corresponding general standard of conduct to be applied subject to the principle of common but differentiated responsibility and respective capabilities. Under these circumstances, the Court recognizes that the standard of due diligence for preventing significant harm to the climate system is stringent. As concerns climate change, a heightened degree of vigilance and prevention is required. The Court concludes that the duty of states to prevent significant environmental harm applies in the context of climate change, and that this duty forms part of the most directly relevant applicable law. Concerning the duty to cooperate, the Court recalls that it lies at the core of the Charter of the United Nations and has been spelled out in the Foundational Declaration on Friendly Relations. The Court has held that the adoption by states of this text affords an indication of their opinio juris as to customary international law. That observation also applies to the duty to cooperate, insofar as it finds expression in many binding and non-binding instruments relating specifically to the environment. The duty to cooperate is a central obligation under the climate change treaties and other environmental treaties. In view of the related practice of states, the Court considers that the duty of states to cooperate for the protection of the environment is a rule whose customary character has been established. This duty to cooperate is intrinsically linked to the duty to prevent significant harm to the environment, because uncoordinated individual efforts by states may not lead to a meaningful result. It also derives from the principle that the conservation and management of shared resources and the environment are based on shared interests and governed by the principle of good faith. For these reasons, the Court considers that the duty to cooperate for the protection of the environment forms part of the customary international law and can also serve as a guiding principle for the interpretation of other rules. It forms part of the most directly relevant applicable law. Turning to human rights law, the Court considers that the core human rights treaties and the human rights recognized under customary international law form part of the most directly relevant applicable law. The Court then examines whether certain principles are part of the applicable law for the purposes of the present advisory opinion. It concludes that the principles of sustainable development, common but differentiated responsibilities and respective capabilities, equity, intergenerational equity, and the precautionary approach of principle are applicable as guiding principles for the interpretation and application of the most strictly relevant legal rules. The Court finally turns to the question of whether any of the rules identified above are excluded by virtue of the interpretative principle of lex specialis. This question concerns the relationship between the climate change treaties and other rules of international law. The Court notes at the outset that it is a generally recognized principle that when several rules bear on the single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The principle of lex specialis is a maxim of interpretation that is used for determining which of several potentially applicable rules is to prevail or whether the rules simply coexist. The application of the lex specialis principle depends on the circumstances of each case. The Court cannot find any actual inconsistency between the provisions of the climate treaties and other rules and principles of international law that may be relevant for the response to question A. On the contrary, the preambles to the Framework Convention and the Paris Agreement themselves contain references to other rules and principles. The state parties to these treaties have thereby recognized that climate change constitutes a problem for whose solution other rules and principles also play a role. Nor the Court identify a discernible intention of the parties to the climate change treaties generally to displace other possibly applicable rules or principles. There is in particular no indication that the climate change treaties are meant to apply while simultaneously excluding general customary international law or other treaty rules on the protection of the environment. For these reasons, the Court considers that the argument according to which the climate change treaties constitute the only relevant applicable law cannot be upheld, and finds that the principle of lex specialis does not lead to a general exclusion by the climate change treaties of other rules of international law. The Court emphasizes that it has determined only the applicable law which is most strictly relevant for answering question A put to it by the General Assembly. This determination is without prejudice to other rules of international law that may also be relevant under various circumstances in the context of climate change. The Court then turns to the obligation of states under the Climate Change Treaty framework, which comprises 3 legal binding instruments concluded by states to address the problem of climate change caused by anthropogenic GHG emissions, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement. The Court takes into consideration the rules, principles, mechanisms, and institutions established under the climate change treaties in order to identify and clarify the obligation of the parties. In this context, the key principles that permeate all 3 climate change treaties are those contained in Article 3 of the Framework Convention. These guiding principles include common but differentiated responsibilities and respective capabilities, the precautionary approach of principle, sustainable development, equity, and intergenerational equity. The Court recalls that while these principles do not constitute standalone obligations within the Climate Change Treaty framework, they guide the interpretation of the treaty obligations. In interpreting their obligations under the climate change treaties, states also need to have recourse to the relevant decisions of the governing bodies of these treaties, which are the Conference of the Parties of the Framework Convention, the Conference of the Parties serving as the meeting of the parties to the Kyoto Protocol, and the Conference of the Parties serving as the meeting of the parties to the Paris Agreement. The Court observes that in certain circumstances, the decision of these bodies have certain legal effects. First, when the treaty so provides, the decision of Conference of Parties may create legally binding obligations for the parties. Second, decisions of these bodies may constitute subsequent agreements under Article 31, paragraph 3A of the Vienna Convention on the Law of Treaties, insofar as such decisions express agreement in substance between the parties regarding the interpretation of the relevant treaty. The Court observes that it is not required to address each and every obligation of the parties under the climate change treaties. It focuses its inquiry on the main obligations of states under the Framework Convention, the Kyoto Protocol, and the Paris Agreement pertaining to the obligation to protect the climate system from anthropogenic GHG emissions, which it considers may be grouped broadly into obligations of mitigation, adaptation, and cooperation. Concerning the relationship between the Framework Convention, the Kyoto Protocol, and the Paris Agreement, the Court observes, with respect to the applicability of lex posterior rule, that it is only where the treaties are incompatible, i.e., their obligations cannot be complied with simultaneously, that the later in time obligations will supersede the earlier obligation. The mere fact that the treaties regulate the same subject matter does not necessarily constitute a conflict or result in one superseding the other. In the view of the Court, there is no incompatibility between the 3 climate change treaties. On the contrary, they are mutually supportive, with the Kyoto Protocol and Paris Agreement providing greater specification to the general obligations contained in the Framework Convention. the Court turns to the obligation of parties under the Framework Convention. It observes that the Framework Convention provides a general framework for addressing the problem of climate change caused by anthropogenic GHG emissions. In this connection, the Framework Convention addresses the full range of GHGs, with the exception of those already controlled by the Montreal Protocol. The ultimate objective of the Framework Convention, as set out in Article 2, is to achieve stabilization of GHG concentrations in the atmosphere at the level that would prevent dangerous anthropogenic interference with the climate system, and to ensure that such a level should be achieved within a time frame sufficient to allow ecosystems to adapt naturally to climate change, to ensure that food production is not threatened, and to enable economic development to proceed in a sustainable manner. A key feature of the Framework Convention is the distinction it draws between developed country parties and developing country parties, which are subject to differing obligations. The Framework Convention accomplishes this by providing for specific additional obligations on certain developed country parties and other parties listed in Annex 1, which I shall refer to as Annex 1 parties. The main obligations under the Framework Convention concerning mitigation are to be found in Article 4, Paragraph 1. The Court observes that certain obligations under this provision, such as those to develop, update, publish, and make available national inventories of anthropogenic GHG emissions and removals by sinks, the obligation to formulate and publish national programs, and the obligation to communicate information to the COP are obligations of result. Other obligations under Article 4, Paragraph 1 are obligations of conduct, because they do not require parties to bring about a particular result, but rather require parties to use their best efforts to achieve certain results relating to mitigation. In the Court's view, the obligations under Article 4, Paragraph 1 are interconnected obligations of conduct and result. The Court further observes that Article 4, Paragraph 2 sets forth a number of distinct but interrelated mitigation obligations that are legally binding for Annex 1 parties. The Court finds it necessary to recall that all obligations identified are legally binding upon the parties to which they pertain, regardless of whether the obligation in question is one of result or one of conduct. As the Court has observed, the distinction between obligation of conduct and obligation of result is not necessarily a strict one. It must be stressed that both types of obligations may result in the responsibility of a state for breach of the relevant obligation. With regard to adaptation obligations under the Framework Convention, the Court observes that adapting to the adverse effects of climate change is, along with mitigation, a major area of action for parties under the Framework Convention. Several provisions of the Framework Convention refer to obligations relating to adaptation. These provisions, like all provisions in Article 4, Paragraph 1, are introduced with the term shall and are legally binding in nature. While the aforementioned obligations pertain to all parties, Article 4, Paragraph 4 of the Framework Convention provides that Annex II parties shall assist the developing country parties that are particularly vulnerable to the adverse effects of climate change in meeting the cost of adaptation to those diverse effects. This is a legally binding obligation on all parties that are listed in Annex II. The Court further observes that the Framework Convention establishes an obligation for parties to cooperate in different areas, including in mitigation and adaptation. The Court considers that international cooperation is indispensable in the field of climate change, and that the customary duty to cooperate for the protection of the environment is reflected in several provisions of the climate change treaties. The duty to cooperate is an obligation of conduct, the fulfillment of which is assessed against a standard of due diligence. The Court then turns to the Kyoto Protocol